case of Minister of Lands and others versus CFU, in which an application for recusal had to be dealt with as a separate application, which had to be filed. There was not a specific issue as to whether or not they ought to be separate and specific. It was assumed, and I think correctly so, in our submission. Then in the South African cases that I've cited, the President of the Republic of South Africa and others, and Judge President Lope versus Premier Western Cape, it's also apparent and very clear there that the court dealt with recusal in terms of a specific application that had been made for the purpose. That is the first basis for our submission, that there is no application for recusal. But the second basis turns on principle, which is in terms of the rules of this court. For a person to get relief from this court, it is tried that there ought to be an originating set of papers we call pleadings. And it is from those originating papers that relief can be obtained. Our rules provide for applications, which is one way of approaching this court. The other procedure is where you are approaching this court by way of an appeal, or you are in this court by way of a referral, and then the exceptional situations where this court may want to make some decision, but that has to be because there is an application before it. Our reading of Rules 14 and 16 of the Constitutional Court rules, by necessary implication, means that you ought to always file an application if you need any relief from this court. If those rules are properly construed, my ladies and my lords, it is very clear that relief ought to be indicated by the litigant in terms of a draft order. The other parties have to be given an opportunity to respond. And this is in writing. You